And what in heaven's name brought you to Casablanca?
My health. I came to Casablanca for the waters.
The waters? What waters? We're in the desert.
I was misinformed.
He told me, keep your friends close, but your enemies closer.
The ability to speak does not make you intelligent.
You're tearing me apart!
What?
You say one thing, he says another, and everybody changes back again!
It's the Al Travis Show, and it's time for The Court Report, a bi-weekly segment with the Upper Midwest Law Center, a nonprofit public interest law firm on the front lines dedicated to defending constitutional freedoms and the rule of law, and we're happy to have him. He's Doug Seaton, founder and president of the Upper Midwest Law Center. Sir, thank you for being on the program today.
Thank you, Al. Very glad to be with you today. Exciting times.
Well, and if you don't mind, really some self-congratulations on to you. I just think you can't miss these times. When did you start up Upper Midwest Law Center? How long ago?
7 years ago. So
7 years ago, little Dougie, as we like to call him back then, has a dream. He wants to fix some things. What was the goal of the Law Center when you started it?
Well, we started this battle just kind of passing the hat before that time and saying, gee, we got to fight this, we got to fight that. It's just wrong, and nobody's standing up to do it. We realized you can't do it that way. It's just too awkward, too clumsy. My partners weren't happy with me. So we started the Upper Midwest Law Center thinking, I think there are some people out there who want to fight back, who don't have the means we have. I've got a law license. I'm not answering to anybody. I can fight if I want. And that's how it started. And luckily, we got that support.
And so I guess what I want to stop down and say, and maybe you'll have another one, but yesterday, but we're talking about it today, has to be one of those high water marks of what you decided you wanted to do to make a difference and stop people. I want to just say is I'm happy. I'm sitting here and I'm a little welled up. I'm talking to the guy who said 7 years ago, this is what we're going to do. And you knocked it out of the park, my friend. I mean, that's grand slam, touch 'em all, Kent Herbeck stuff right there.
Thank you very much, Al. We're very blessed, but we do think we've done the work and we earned it.
Well, yeah, and you have. So for folks, what we're talking about is an omnibus bill was passed at the end of the 2024 session. It covered everything from paid family leave to this binary trigger gun thing and just 1,400 pages worth of stuff. A group got together with you. I don't have it right here. Minnesota Gun
Owners Caucus.
Gun
Owners Caucus. Yes.
So they come to you and say, this isn't right. We don't like it. And I presume many companies, many businesses, many organizations don't like something in 1,400 pages, but they came to you and they said, what can you do? And you looked at it and said, I mean, how do I put this? This law is pretty common sense for a knucklehead like me even to read. And you saw it, but this must be about the 6,000th time this has been done in the last 30 years.
It is amazing. I had the honor to fight this same battle back when they were passing 300-page omnibus bills. Now it's 1,400, as you said. And the court warned them 25 years ago, don't do this anymore. When we knocked the one down, I had the honor of being in that fight, too.
Did not know that.
25 years ago. And so finally, we're coming back to the court saying, you warned them, they're doing it again. Can't there be some consequences? And luckily, Judge Castro was willing to say, yes, this has got to stop. So we're on the way to having this process be ended. They're not going to be able to do this anymore. I think it's pretty clear.
And for folks, I don't want to spend a lot of time reading law, but I think how simple this is tells knotheads like me, I get it. This is Article 4, Section 17. This is the entire law. Laws to embrace only one subject. No law shall embrace more than one subject, which shall be expressed in its title. That's our Constitution.
That's it.
I'm sorry.
Very simple.
How has it been in the last 30 years? This isn't a Republican-Democrat thing because each side has done this. How is it that these people don't read that and understand it? How has it been able to happen for the last 25 years?
Well, unfortunately, it's very easy for legislators to say, gee, we've got this bill that's supported by 1/3 the legislature. We got this other piece supported by another third and try to assemble, log roll a majority when these individual pieces would not have a majority to pass the legislature. And that's exactly what the Constitution doesn't want to have happen. The Constitution wants the people to be able to see what's this legislation, what does it do, and hold people accountable for their vote one way or the other. And this omnibus stuff tries to mask that and tries to beat the Constitution and the legislative process. And it's a bad thing. And we're very glad we can help roll it back.
All right. And not just roll it back. This is what I find, and I'm no lawyer. You tell me if I'm wrong. So the binary trigger, and to be quite frank, as I understand it, this binary trigger, the judge didn't say that was wrong, that bill was wrong. He said it couldn't be in this overall bill, right? He didn't make a judgment on the binary trigger, just where it was at. Is that correct?
That is absolutely right, Al. We could have challenged this. They could have on the Second Amendment grounds that this goes too far under the Second Amendment, and we're fans of that, as are you, and as is the Gun Owners Caucus. But that wasn't necessary here. All we had to say is this bill is unconstitutional under the single subject rule. And so that's it. That should be struck down. And since we've got this interest in not having this ban take effect, we get to be a plaintiff. We get to say that to the court. And that's how it all worked out. We should have had more. We hope to have more. You know, movements like, Al, you can't get everybody in one room to agree and join in together at any one time. And so we had one client. That's good enough. And we took it away.
See, but that's the one client thing. And I've been saying, and sir, I don't know if I dreamt it, read it somewhere, pulled it out of a hat. Let's say it costs $80,000. If Al got offended by a thing and the Al bill came in and I wanted it, and I got to get a lawyer and I go to the court and then we go to the thing and I got to, and let's say I got to spend $80K. Most of us, it becomes out of reach, right? I mean, I can't do it. I'm not going to, it's not that important to me. But now we're looking at if this is true for the binary, the Minnesota Gun Caucus. There's 100 other things inside that same bill.
Yes.
Right? It's 1,400 pages. So many? So now is this a flood to the courts now? Everyone says, wow, I'm in there. This had nothing to do. Is it a flood now? And do they don't necessarily have to go through you, but I presume you wouldn't mind. Is that what's going to happen? The Supreme Court's going to get 85 cases now? It
could be. Unless the appeals courts themselves, if the AG, as you know, has said he's going to appeal this, and if he does, the appellate courts will be in a position to say the whole thing should go. So the AG has some risk in appealing this decision. We don't have to appeal. Maybe we will. I don't think we really have grounds, perhaps, but we're going to follow it. And if it is appealed, we'll certainly be in that fray saying, go the whole distance, court. It goes to the appeals court and then the Supreme Court, as you know, in order in Minnesota on a case like this.
But am I wrong that if people are looking at that bill and they weren't happy with things that got passed, because when maybe I'm not understanding, maybe we can go to break early and I'll ask you this on the other side. I'll ask you first. You'll know what I'm talking about. Is this fruit of the poison tree thing? It's like the only law words I know. But if this doesn't count because it was in an omnibus bill, then isn't the whole thing, the whole omnibus bill, wrong and they have to get started over? Isn't that what they said? Can a judge just say the reason you lost is because it was in an omnibus bill, but the omnibus bill still stands? Can he do both? Not on this side of the break, on the other side. I've got him. He's the president, the founder of Upper Midwest Law Center. They are flying high. This could, in my opinion, change the way we do laws forever again in Minnesota, and I think in a very positive sense. We'll talk more with Doug right after this.
Think about it. A famous politician once said, "You're entitled to your opinion, but you are not entitled to your own facts." But in a world full of AI and fake news, where can Minnesotans find the facts? Center of the American Experiment is Minnesota's go-to source for fact-based analysis and common sense solutions for taxes, energy, public safety, and our kids' education. Visit AmericanExperiment.org for more information. Think About It is brought to you by Center of the American Experiment, Minnesota's think tank.
Step into a world where magic and merriment come alive. Discover fantastical creatures, behold thrilling jousts, and meet your favorite characters of old. From rib-tickling gestures to spellbinding performances, the adventure never ends. Make memories that will last through the ages at the most magical village on earth, the Minnesota Renaissance Festival. Plan your visit today at renaissancefest.com. Huzzah!
The Al Travis Show, the last place you can go and hear all sides. Respectful, thoughtful, and grateful.
We've got him. He started up at Midwest Law Center. He's Doug Seaton. Sir, what we're talking about is, so the binary trigger rule that the judge said it doesn't count isn't because of the law about the trigger system itself. It is because it was in this omnibus bill. Does that mean all of that omnibus bill is bad? Can you really say, I'm not judging on the merits of the law, I'm judging where they passed it from? And if that's bad, isn't it all bad?
Well, in a manner of speaking, Al, we think it is. Now, the judge said flatly that it's an unconstitutional process they followed. It's an unconstitutional bill. And that's the opening to everybody to look hard at what their concerns are and go to court if they can. But from our point of view, it was our client's interest in this particular provision that led the judge say, we're going to sever that, take it out. It's not effective. It's not law, period. Okay. And obviously, that's a big win. We're very excited about it. But we would prefer to have the whole bill fall because we don't think the legislature is going to get the message otherwise that they can't do this anymore. So we're hopeful the appeals courts will take it further, because that's the invitation the district court's giving, is saying to the appellate courts, they have a broader jurisdiction. Yeah. You take it up and you say it's all gone.
And who has the standing in that? This thing about standing, I get the Minnesota Gun Owners Caucus has something to do with this trigger thing, and that makes sense. Could the Al Travis of Minnesota come out and say, I've been upset about the way they've been passing these bills for forever. I think I have standing. Could I just go for the whole enchilada instead of getting 80 people or 80 organizations? Could one citizen stand up and say enough is enough?
I don't think so, Al. I think the courts are going to say not quite. You got to have a particular interest involved. We've got this thing called taxpayer standing, and that's limited to cases where taxpayers can say, I'm paying dollars that are going into this bad thing, and I want it stopped. That you can do that. We've done that in school district cases, but you can't do it here. You have to have more than that kind of undivided citizen interest involved. But anybody is impacted by this bill will have standing, in my judgment, to go forward and say, we have this piece of the bill that's hurting us. You said the bill's unconstitutional. We want the whole thing gone, or we want our piece severed out too. And that, we think, would be a viable lawsuit. People who are affected by the Family and Medical Leave Act, gargantuan tax and cost and crazy planning, small businesses can't survive this, as we all know. And so those people can come forward. People affected by independent contractor restrictions that are improper, they can come forward. Lots and lots of people have interests affected here and can bring their cases forward, in our judgment.
All right. Well, this is a big law question because I don't know much, but instead of 80, I don't know how many in 140 bill, 1,400 page bill, 80 of these guys come forward, all want to go after their piece of that nugget. And the courts see that, oh my goodness, it's 80 of the same cases. It's just grinding through. And again, get to next year and they're passing more bills on top of this bill. Can you unwind the spool? Could the Supreme Court jump in and say, we see the legal battle here, we need to discuss this and find out whether they can do it? Can the Supremes get in before we go down this road so far you can't undo it?
I think they can, and I hope they do. If there is an appeal, the AG's threatened to appeal this decision. If he does, we hope the appellate court and the Supreme Court finally say, we're going to take care of the whole thing. We hear Judge Castro's comment that why should 100 Minnesotans have to go to court to get this right? We hope they will take it up themselves and say, that's not necessary. This is over. Don't do it anymore, and set some clear parameters to enforce that single subject rule in all of our interests. That's in all citizens' interests, not just gun owners, not just small businesses, not just whatever.
How do you think people accept this? I had a senator on and a lawyer as well talking about that bill, which I read out loud, and they said it's the comma which shall be expressed in its title. And supposedly they've been doing this with the idea that if you make the title of the bill and you put 65 different things down from paid family medical leave, that somehow that's lawyerese to get this by. I never thought it was all that complicated until we had to have a huge Supreme Court argument over what a quorum is. Is that really an open-ended statement that I read? That's one subject, put it in the title?
I don't think so. I think ultimately this is a fairly clear-cut matter, and that the courts will boil it down to that when they finally get down to business on this. Because both pieces of that are important, but the single subject is the critical piece. And the courts have said there's just no single subject here. You can't say all these things have to do with taxes or state government, depending on the case. You have to have a real title, and it really has to express a single subject, and that's got to be everything in the bill has to relate to that subject. And that means we couldn't have this bill, of course. There's no way you could make this bill fit within a single subject. It is just isn't true.
So what would they gain, the AG, Walz, the governor, by taking this any further? I guess they open themselves up. If they get the wrong answer, they're going to blow this whole thing out of the water. And if I'm not mistaken, right now, the trigger bill is the only thing that's pulled out. So you take 1,400 pages, lose the one for this, they're up. Why would they open this can of worms?
Well, that's a very good question. They've said they're going to appeal, but they haven't actually done it yet. And I think it's sort of politically motivated. Oh, guns are bad, and people who have guns are bad, and blah, blah, blah. That's their mantra on the left, of course. So that may have driven the decision or the statement about appeal. Whether they do it or not is another matter, because they have some real risks in doing it. And you've spelled them out.
But again, it's all or nothing for them. They lose this bad boy, and that whole bill falls apart. Again, back to talking about something the senator said. How do we unwind that? There are things that are starting that are going on. We pass in 2024 that would be unconstitutional, not lawful. I told him, just because you did it wrong for 30 years doesn't mean you get to keep doing it, and we're not going to go back. Sir, I love having you on the program. I thank you for doing that. I'm happy to be a part of that. We're here this first week. When you blew this out of the park, this has got to be what you set this whole thing up for.
Exactly so. We're so excited to be doing the things we said we would do to help advance the rule of law, defend the Constitution, stop the bureaucrat abuses, stop the unconstitutional actions, and get Minnesota back to being a constitutional republic. That's what we hope to do, and I'm very glad we've started to do it. We're excited.
I love it. That's all the time we have today for Court Report with the Upper Midwest Law Center. Thank you for the insights into your mission to defend liberty and the rule of law. For more information on cases and issues we discussed today, you can learn how you can support their fight. Visit umlc.org. We'll see you in 2 weeks for the next Court Report.